Ask members to elect a chairman for this meeting. Okay, thank you. Is it unanimous there? Councillor McKee is chairman for the meeting.
Right, good morning everyone. Thank you very much. Welcome to this meeting of the local review body, Wednesday 9th of April. Please note that this meeting will be recorded and subsequently made available to the public for listening purposes. Claire, would you like to take us through the process? And given it's only us, didn't you read everything, please? Oh, what I'm suggesting is that Claire doesn't read through all this paperwork, given there's no members of the public here. Do you want it all read out, or the main points?
I suspect, Chairman, that we should probably absolutely do the thing to the letter of the law. Yes, so that everybody believes that we've had everything. So forgive me, but I think probably we should hear everything.
Okay, thank you. Right, Claire, I'll leave it to you. Thanks very much.
Sorry, Chairman, can I just firstly ask you to do the Sederunt apology?
Sorry, we have apologies.
Yes, we've got apologies from Councillor Ogilvie.
Thank you. Have we any declarations of interest? No?
No.
Okay. Right, Claire, I'll leave it to you now. Thank you.
Okay, thank you very much. We have one item for review today, that being item 4, 26 Liddesdale Road, Stranraer, refusal of planning permission for erection of two-storey extension to rear elevation of dwelling house, 13P10359. The main points for the review are that the grounds stated in the notice of review are, in summary, that the applicant considers that the precedent has been established by an extension allows on a dwelling house near Portpatrick. He considers the extension cannot be seen from the main road. He raises concerns about the processing of the application, claiming that officers have been inconsistent and alleged lack of response to correspondence. You have the grounds of refusal in your papers being that the proposed rear extension, by reason of its general design, mass, scale and proportions, would be out of keeping and detrimental to the character, scale, massing and appearance of the original dwelling house. The proposal does not comply with the Wigtown Local General Policies 1 and 9 and the guidance provided in Supplementary Planning Guidance Number 2, Design Guidance for the Built Environment. In your papers, you've also got all the comments for the interested parties and the relevant development plan policies. So the main issues for the LRB to consider are: does the proposal conform with the relevant development plan policies, and in particular General Policy 19, and to the guidance provided in Supplementary Planning Guidance Number 2? And if the LRB considers that the proposal does not comply with the development plan, are there any material considerations which would indicate that planning permission should be granted to the contrary? And how much weight, if any, does the LRB wish to give to the applicant's claim about the precedent set at another development near Portpatrick? So it now falls to the LRB to determine whether it has sufficient information to consider the review, and it's confirmed there would be no representations from any party here today. The LRB has the following options. It can decide it has sufficient information before it to enable it to determine the review today, request further information in the form of written representations. In doing this, the LRB will have to state precisely the information it is seeking and who must provide it, resolve to hold a hearing, again specifying who will be invited to speak and on what matters, or resolve to hold a site visit, accompanied or unaccompanied, This can be done in conjunction with any of the above, but would obviously not allow a decision to be made today. And if the local review body resolves it has sufficient information and that no further procedure is required, then the local review body has the full powers to uphold, reverse or vary a determination. The decision notice will include a statement of the terms in which the planning authority has decided the case reviewed. You have an independent planning advisor present to assist with this item. It is confirmed she did not have any involvement in any of the cases and is not the case officer or appointed officer for the application. She is purely here to provide independent advice on matters of planning policy, law or process of the local review body. So if members are clear and no further clarification is required, I will ask the chairman now to lead the debate. In the first instance, to lead the local review body through the agenda papers together and decide if it has sufficient information before it can make a determination today.
Thank you very much. Claire, I should introduce Jessica Taylor as our planning advisor today. And it be my intention just to highlight sections, and if you have any questions in those sections, just to raise them as we go. I'll start with the notice of review, page 3 onwards. On page 11, there's it's an attachment that was sent in with the planning notice of review, and the actual notice of review contained in the papers answers some of the queries that's been raised in this on page 11. Is there anything else on that? No. Okay. Move on to report on handling, page 15 onwards.
We're dealing at the moment, Chairman, if I've got this right, in respect to the information in these. So we're checking whether the information is complete.
Yes, that's right. We'll go through this, and if we're happy with enough information, we'll then go into discussion if you like. But if there's any items you want to raise in this each section, just raise them. Observation of interested parties and the appointed officer on the applicant's notice of review, page 23 onwards. I should highlight on page 27, paragraph 2, with regards to comments about a precedent having been created, it remains the case that each application falls to be considered on its own merits and in the context of prevailing circumstances at each particular location.
It was just I suppose, a point of clarification, just on the email correspondence, page 29, just to ensure that we've got the full information. One of the points raised earlier in the letter was that some of the questions hadn't been addressed. And in the email correspondence, I'm just wondering if this is sufficient in terms of like the response to do with the rationale behind the decision based on the scale and massing, etc. Because I believe in the correspondence, the applicant had asked for a detailed assessment on the being unsympathetic to the scale and character of the existing building, and I appreciate that was referred to the area planning officer, but just to make sure that could the applicant have expected to get a response to that particular question prior to the referral to area planning, and whether or not that should be considered material in this case.
The only thing I would highlight would be the final paragraph in that email on the top of page 30. There are many examples of recent extensions throughout the region where building proportions of new to existing are far greater in this case. With this in mind, as things stand, please be in no doubt that the application will not be amended and any refusal will be referred for appeal to citing these examples. So they're ignoring each case being done on its merits, and I think what the planning officer is saying, that by the time he got that, I think it had been forwarded to the senior planning officer for their area planning manager for final consideration. So I think what they're saying, they were too late in putting that request in, albeit they weren't got to change anything, but they still wanted to meet them.
It was more a sort of minor point in terms of communication between the officers and the applicant in terms of would it have been considered normal to at least give a response to that particular question? Thank you.
Yeah, it's usual for officers to express their concerns in writing and ask the plans to be amended. And I think they came back and said they weren't prepared to amend it. And that at that point, we usually, they've asked for it to be determined and we don't engage in any further correspondence. If they're not willing to amend the plans or engage in any negotiation, then it usually just leads to the application being refused. If it had been the case where they'd come and said, yes, we're willing to negotiate and come up with a better scheme, then further negotiation would have taken place.
Yes, I hear what's being said. We don't set precedents by what's happened before, and each case is looked at on its own merits. But I just wondered that the applicant cited the specific case of the building at Port Patrick. I wondered if we would have responded with some more information about that specific building in terms of, say, its... I mean, we have figures, for example, of the proposed extension to this property, which is, what, 40 square metres vis-a-vis the footfall of the... it looks like a 50% increase anyway. Would it be useful to have had some comparable percentages concerning the Port Patrick building? I mean, or is that just something you wouldn't do? Would you not go drill down into such detail as that?
Yeah. No, we wouldn't usually seek a comparison because we're judging everything on its own merits. The difference between, I think, the two cases is the relationship between neighbouring properties as well, and the circumstances between the two sites. The case officer isn't available anymore for the one that was approved. But we have to assess it on individually, so it wouldn't be normal that we would compare.
Would that be just not quite digging a hole for yourself, but basically saying, well, that could be used by an applicant to say, well, you're disallowing a 50% increase here, whereas you allowed a 60% somewhere else. But of course, you have to look at the whole picture, I suppose, in terms of the siting of the building and other matters. Would that be correct?
Yeah, that would be correct. There's so many variable factors that we couldn't just give a set amount and say that would be acceptable in all locations.
I think if it had been close to this site, then there might have been an argument. Given it's miles away, you can't compare different estates, if you like, and things like that. Councillor Maitland?
Well, Chairman, we're being asked whether or not we have sufficient information, and I follow on from my fellow elected members' views, Councillor Thompson's views, and questions on the emails. But it seems to me that it's perfectly clear that there is an email that goes out from the planning officer on December the 2nd, just about at 12:46, saying, referring to a conversation and asking, suggesting what the belief is of the planners and asking for amended drawings, and back comes a message saying no. With this in mind, and as things stand, please be in no doubt that the application will not be amended. And I have to say, I think that is very clear. The information to me is that it wasn't going to be amended. So I think we have to say we've got the information here and we have to decide on what's here. So I'm quite satisfied in that respect that I do have sufficient information.
So I don't think there was any need for it. There was no justification for a meeting given they said they weren't going to change.
Exactly.
Right, can we move to planning application form, page 33 onwards?
Chairman. Yes, the drawings that would be submitted, I must confess, I mean, I would draw members' attention to the drawings on page 42, 43, 44, it must be. And you can see how the extension would come up above from the front of the existing building. You can see how it would come up above. I also think it projects up higher than the existing roof line, and in addition to that, there's a discordant note because the pitch of that roof isn't even in line with the existing pitch, and that's why I feel that in terms of detail, I would have looked at this. I'm very satisfied again that it makes it perfectly clear. These drawings are completely clear that is what is proposed. There's no doubt about the scale and the shape and the design of the building. So I'm quite happy with that application.
Thank you. No more on that section. Decision letter from Dumfries and Galloway Council dated 6th of January 2014, page 49 onwards. You got, no, right. Relevant extracts from the Wigton local plan. Copy of supplementary guidance number 2, design guidance for the built environment.
Noted.
And page 67 onwards, photos of the application site and the locality. Do you consider you've got sufficient information in front of you to make a decision today?
I do, thank you. Yes, indeed, thank you.
Thank you very much. Have you any questions you want to ask? I'm quite happy with what you've been through.
Been locked out. So just to run you through the site. So this photograph shows the front elevation of the property, and you notice to the left-hand side is the neighbouring property, which is 2-storey. And looking again, the front of the property is to the left, and you've got the neighbouring property, which is 1-storey on the right. Just moving into the site, so you're looking at the side elevation, and you can see the existing conservatory at the rear. And now we're at the rear of the property, so we can see the conservatory, and then behind that is the space where the proposed extension is going to be. And again, you can see closer up of the site. And again, the neighbouring property, which is 2-storey in the rear of the background. So it's might be quite useful to look at the plans on page 40, 45, because you can see the relationship between the conservatory and the proposed extension. It measures approximately 2.7 metres higher than the existing conservatory. And this photograph is taken looking back towards the rear boundary, with the trees that are mentioned in the objector's letter. And looking at the front again, you'll see on page 45 again the photograph of showing how the extension will be visible from the front elevation.
Thank you, Jessica. Anybody any questions on that? Councillor Maitland?
It's just about the relationship of the height of the building with the next one. I don't think that's really the issue, personally. I'm not concerned with the so much with the relationship of the height of the neighbouring building. It's a two-storey building, and I think it would be perfectly reasonable to accept a two-storey building if it wasn't going to have the effect on the existing dwelling, the building to which it will be attached. And I'm very happy to hear from other people, but my view is that we should be looking at the effect that this extension has upon the existing bungalow.
Councillor Thompson?
Yeah, it was just a more sort of general question about, obviously Councillor Maitland had pointed out earlier about the angle of the proposed extension, and if there was, I mean, is the assumption that normally that would be if it was sort of parallel or in line, you know, in terms of the existing sort of roof line or the angle of the roof? Is that, I mean, is that considered, or is there a sort of guidance on that generally if extensions are being considered?
There's no general right or wrong. It depends how the design works with the existing dwelling. In this case, it's considered it doesn't work. There is other cases where it might work, and that would be turned on the design. So there's not a right and a wrong. But in this case, it's considered it doesn't accord with the existing dwelling.
Councillor Wicks?
Looking again at page 44, Chairman, just for the avoidance of doubt in my mind, we've got two proposed east elevations, top left and bottom right. I'm a bit confused there. Clearly the one on the top left shows the conservatory. Is that from the rear of the building? But for us, I think my colleague is going to clarify this for me. Oh, yes.
Chairman, Councillor Witts is absolutely right. I had to look at this 2 or 3 times and had to put in the directions to get an idea, because they're not actually correct.
So I take it the bottom right one is from the street and is a southwest elevation. That's looking from the southwest. Okay, that's the wee bit. No, okay. More than a wee bit.
Yeah, I notice the extension comes around the outside of the house as well. It overlaps side of the house. Councillor Maitland?
Well, Chairman, I would propose that actually, having looked at this quite carefully and considered the issue of not responding, the complaint made by not responding, those are the issues that we've got to consider. I think the issue of the response is quite clear in that it was absolutely obvious they were not going to change the drawings. The drawings were as they were, and come what may, there was no point in re-engaging at that point. It was clear and written down in black and white. So I think that issue is dealt with. And my view that the original decision made in the report on handling is correct, and I see no reason to deviate from the refusal on the grounds there.
You're in agreement with the decision made on as page 52?
That's what I would suggest, Chairman, yes.
Thank you very much. Anybody? Councillor Witts?
No, just to concur with Councillor Maitland, agree with that.
Thank you. Councillor Thompson?
Yeah, I mean, I think my initial concerns were just to do with the appropriateness of the correspondence, but obviously given the determination not to change any application based on the advice from planning officers, and also the discussion and the investigation of the site plans and drawings and the intention, and the decision made about the inappropriateness of the scale and massing, etc. I think if we were doing this from scratch again, we would come to the same decision. So I'd be happy to go along with the rest of the members.
fine. Claire, we've decided to uphold the decision made by the planners as per page 52, refusal of planning permission.
Okay, thank you. And just to again confirm the decision that the local review body has upheld the decision of the appointed officer to refuse planning permission for erection of a two-storey extension to rear elevation of dwelling house at 26 Liddesdale Road, Stranraer, 13P1 0359.
Okay, thank you all very much. You can now go and sunbathe.